What is a notice of intent to deny? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. USCIS, U.S. Citizenship and Immigration Services, they process immigration cases. And if they feel that there's information lacking from a case, whether it's a I-130 petition, a 485 adjustment of status petition, or a N-400 naturalization case, they can issue what's called a request for evidence. A request for evidence means that, hey, you haven't satisfied your burden, you haven't submitted enough evidence, and we want you to send us some more stuff. It might be your medical exam, it might be taxes, might be background information, might be more marriage evidence if it's a marriage-based green card case. In any event, there are regulations that govern requests for evidence. There are also regulations that require USCIS to send you what's called a notice of intent to deny, or just a written notice. We call them NOIDs in our office, N-O-I-D, notice of intent to deny. They're supposed to send you a notice of intent to deny if they think your case is headed towards a denial. There's a regulation on this, and I'm going to read it to you straight from a lawsuit that we filed recently challenging USCIS's failure to issue a notice of intent to deny. 8 CFR 103.2 subsection B, subsection 16, subsection I requires that if the decision will be adverse to the applicant or petitioner and is based on derogatory information considered by the service and of which the applicant or petitioner is unaware, he or she shall be advised of this fact and offered an opportunity to rebut the information and present information in his or her own behalf before the decision is rendered. There are some limited exceptions to that, but generally the rule, therefore, is that if USCIS wants to deny your case, and whatever kind of case it is, before they do so, they are supposed to give you a written notice of their intention to deny the case and to give you a full opportunity to respond. So a NOID could come before a request for evidence, or it could come after a request for evidence. But you would be surprised at how often USCIS denies a case without ever having issued a notice of intent to deny. And this is a denial of due process. This is an agency failing to follow its own regulations. So we have used their failure to follow the rules and to issue a notice of intent to deny to challenge denials. We really like hanging our hat on 8 CFR 103.2 because it gives us an entry into federal court, and more importantly, it gives us entry to a higher level of analysis. When we sue them in court for violating the Administrative Procedures Act and for violating the Immigration and Nationality Act, we are the ones asking a judge for help making an agency follow the rules. It's so darn ironic because they love to find little technicalities that might put your case in danger. But when it comes to them following their own rules, nah. Don't do as we do as we say. They don't like it when we call them out for failing to follow their own rules. And this is one of the great reasons why working with an immigration attorney might be a good idea, because we can hold their feet to the fire. We can make sure that they follow the rules. A lot of people would just get that denial and not even know that they have a chance to challenge in federal court the decision that was made if they never gave you the opportunity to challenge or to respond to whatever evidence it is that USCIS thinks that it has to deny your case. So you need to remember, USCIS officers make mistakes. The agency is not God. They are not infallible. They make mistakes all the time. You'll get requests for evidence asking for things that you've already submitted. You'll get notice of intent to deny for things that aren't even at issue in your case. A lot of times they'll do cut and paste from prior notice of intent to deny. You'll have a notice with discussions of other people's cases in them. So don't just roll over if you receive a denial. You have the right to have that denial reviewed in federal court. And if they have failed to issue you a notice of intent to deny, you have a really strong way to get into court, to make your case, and to try to get your decision approved. If you've received a notice of intent to deny, we'd love to help you work on that. We spend a lot of time working on those kinds of cases. Or if your case was denied without a notice of intent to deny, feel free to give us a call, 314-961-8200, if you'd like to hire us to help you with that. You can also email a copy of your NOID, your Notice of Intent to Deny, to us for a review at info@hackingimmigrationlaw.com. If you're just looking for free resources, nothing wrong with that. Just send us an email, just find us on YouTube. You can subscribe to our YouTube channel. I put up new videos all the time. You can also find us on our Facebook group. It's called Immigrant Home. We have thousands of immigrants in there talking about the immigration process. We're also on TikTok at Immigration Hacking. And finally, we do a live show 3 or 4 times a week where I just answer immigrants' questions 3 or 4 times a week for an hour or so. And we'd love to have you join us there. You can find that on the YouTube channel or in the Facebook group. Thanks so much for watching, and we'll see you next time.